Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Recato of Recato Law, a small law firm in central Minnesota. And I do apologize for the tardiness tonight. I had something come up. We'll say I had something come up. So, it is, I almost canceled the show because of it, but that is, oh my gosh, what is happening? That is, yeah, something. No, it's not the kids. It's not anything like that. I'll just tell you guys, someone, managed to get past my 2-factor authentication on Twitch. So that was fun. I don't know how you get past 2-factor authentication on Twitch. I'm not sure how you do that. But in 2 minutes, I lost $10,000. For fuck's sake. So that's how I get to spend my tomorrow. That's how I get to spend tomorrow, getting that fixed. That'll be fun. But the woo. Apparently Twitch has no flagging protocol for wildly aberrant behavior. I have never bought a single bit that I'm aware of on Twitch, but anyway. So, I'm not super worried about it because I'm pretty sure if Twitch won't give it back, that my bank will, because my bank is very, very good and very aggressive on fraud claims. But that is, do you guys want to see the list of people who got my money? We could have fun with it, I guess. We'd have fun with that. Oh my God. Let's see. Here we go. It's the bit usage history. This is what I need. I'm going to do this via snipping. Because, unfortunately, there is information on here that I don't want to disclose. We'll start. How do I want to do this? Let me move this window over here. Okay. So, I've never heard of any of these channels. It didn't all go to one person either, so it's not obvious who did the theft. I kind of wonder, maybe, do any of you guys know about this? I wonder if there's a network where they steal money and give it to people who are in the network. I don't know if that's a thing. Maybe that's a thing. But here we go. Let's take a peek at the Recato Law thought donations. The e-thought donations, apparently. Here we go. So we've got I hope you guys can see this. We've got Bursa and Brolia. Apparently, I gave Brolia $400. And Bursa got this person should be mad. They got barely any money. 5,500 bits for Bursa. Let's see, who else did we here's the bigger list. We'll get everybody. like, look at how all this stuff happened so fast. All of the purchase transactions for the bits happened in 2 minutes. The second I got the emails, I floored it down to my room and de-linked the card and changed my password. But it was not, the bit distribution happened over time after that. So they were already in. They're already in. See if you guys recognize any of these people. That'd be interesting to me. So we've got, these are some big donations here. We've got Crimehan. He got $300. First 3NM1 200. Anki Lol 100. Arya Can 100. Deliconisaur, what the fuck is this? $300. Look at these people getting good donations. The big ones. We got FPS Mini, Jaxers, Generic, Layla. What? They gave the thought more. What is this? What is this? I can't really make, I can maybe make it a little bit bigger. It'll take me more screenshots. I'll do it for the next set. ZT Legends, Tay Fun BYC, Timur Lengix, Phanius. Even in theft, the simp cannot be stopped. That's here we go. Let's get this next set. Yeah, I guess I just have to laugh at this because what else do you do? Right? I mean, I'm super pissed off. Don't take my levity the wrong way. There's just literally nothing I can do about it until the morning. Nerfidin, Laza, Maiko, Madame CC. Come on now. Come on now. Turk Kavesi, Pat Cutes, Lady Medusa, spelled like an absolute idiot. What is that? Machwelo, Meat Hut, Perry Hannum. Perry Hannum. Let's see who else we got here. Whoops. That's the Melinda Scott documents that we're going to get to in a little bit. Here we go. Here is Melisseus, PC Colog, OZGETKC, Warlycia, Script. I've never heard of any of these people. You could tell they were running out of money apparently to give them. So that's good. And then they gave 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 individual bit donations to TwizFizz Epic Gamer. So there you go, TwizFizz. You got 17 bits. Oh, the bit amount on this one? Oh, sorry, here. Here we got 20,000, 10,000, 10,000, 7,500, and 69.85. So yeah, there you go, boys and ghouls. That's made my evening pretty interesting, I guess. I'm a little shocked. Like, they didn't shut down lock me out of my Twitch account. I was able to go in and quickly remove the card. I mean, it's too late. Jason Alator. TwizFizz is a friend of Sophia Narwitz. I raided TwizFizz's channel yesterday, actually. What I believe they did was donate a bunch of single bits to actually fill out the payment history, because the entire front of the payment history is single bit donations to TwizFizz. So they were hoping like I wouldn't notice, I think. I think that was the idea, that they did that. So, I don't know. It's very frustrating though. It's very frustrating. Ah. All right. But yeah. So anyway, we're not here to dwell on my loss of a ridiculous amount of money. Which again, I should be able to get back. Should be able to get back. Pardon me. Pardon me. Okay. All right. What we're going to talk about today, we're going to talk about Joshua Moon's motion or memorandum in support of his motion to dismiss against Melinda Scott. We're going to do that. We're not going to worry about everything else. We also will keep a minor eye on the Georgia election, which is currently split. David Perdue is barely hanging on to a lead over Jon Ossoff, and the Democrat Raphael Warnock is beating a woman, Kelly Loeffler. So I can only assume that as a Democrat man, that Raphael Warnock is used to beating women. That's a joke. That's a political joke, okay? Okay, if you don't know, we might actually, I need to do this more. We might need to have like an announcement on the channel on some of these live streams, because there may be new viewers. There may be new viewers who are here who have caught wind of some of my other content and are anxious to check out the longer form content. So very briefly, if you're new here, these late night live streams are vastly different than the other content you've seen from me on YouTube. They are much more loose. They're much more free. They're full of comedy and jokes and sadness and levity and candor. So it is a conversation. It's a conversation that rambles on and runs for 3 hours pretty much every weeknight. It is not your place to find a truncated and fast answer to the topic. This is not where you come for that. And if you want that, I would just ask you to go anywhere else. This show is a show, and it goes through things, and it's conversative with me and a guest or me in the chat, and we have an interaction, and it is a place for people to relax. If you want a quick hit, like if you tell me to get to a topic, I'm not gonna. I'll probably take longer if you ask me to go faster. All right? That is how this works. It is, again, this is a place to hang out. It's a nice place. We like this place. So, that being said, there is the function called Super Chat. If you want something dealt with or answered, or you want to ask a question, or you want to engage in a topic, you can do it through Super Chat. And the rules of Super Chat are as follows. I will attempt to address $20 and up Super Chats as soon as possible. Now, at the beginning of the show, they do tend to front load. And if I have a guest on, I might, if it's a new guest or something like that, I might let some of them build up as we get to open the show and kind of get into the discussion. And there are mechanical reasons for that involve human interaction and conversation and getting people unaware of the camera and microphone in front of their face. So I know that some people get frustrated with these things, but it's just an easier way to get into it. But if you have a guest, especially a new guest, and you just start immediately reading Super Chats, it breaks up conversation. It doesn't allow the other person to ease into the seat. So that's how this show has been built forever. that's how the show is likely to continue for a while. And if you want to engage in that, you are welcome. Enjoy it. Hang out. Okay. So tonight we are going to be talking about Joshua Moon, the alleged owner of Kiwi Farms, although Matt Jarbo and Akiva Cohen may beg to differ, fighting against a crazy lady named Melinda Scott. Now, Melinda Scott is a woman who has an unknown amount of husbands and an unknown amount of children, but it is more than you think. Whatever that number is, it is more. I can say that confidently. And she has a thread on something called the Kiwi Farms. Kiwi Farms is a website, kiwifarms.net, and I encourage you to never ever go there. By saying that, I know that most of you will. But that is a place, and is one of the last places where speech and information reside on the internet. And opinions are not typically censored. There are a few weirdly verboten subjects, and you will have to take that up with the Supreme Janny, Joshua Moon himself. But in general, most anything goes. That includes the release of personal information, which makes some people very, very uncomfortable. All right? Some people very uncomfortable because some people do not like the idea of their address being posted online. But there's nothing illegal about it. It may not be comfortable, but it is almost certainly legal outside of very, very rare exceptions. And so it is allowed on Kiwi Farms. That being said, Miss Melinda Scott has had some of her private information posted on Kiwi Farms, but mostly a lot of accusations and making fun of her. And she is, for some reason, unable to get sarcasm, jokes, and nuance, and has decided to bring her now fourth lawsuit against Joshua Moon as a result of this. Importantly, not suing the Kiwi Farms, but suing Joshua Moon personally, which is a bad plan. I hope that's a sufficient intro. I hope that it is. Is it her sixth lawsuit? It might be. I thought it was her fourth, but it could be her sixth. I don't even know anymore. I don't even know. And there are other lawsuits she has been a part of that, may be ridiculous as well. So let's hit the initial super chats that are out there, and then we will move into this lawsuit and I'll kind of explain where we are once we get there. AGK says, "Hey Nick, hope all is well." Well, had a question I think you've answered at least once before. How should you respond to an officer when they ask, "Do you know how fast you are going?" If you maybe exceeded the limit slightly. I would say nothing or just say no. You know how fast you're going? Nope. That's it. That's what I do. It's not illegal to not know how fast you're going. And realistically, you don't. You don't actually know how fast you're going. But the reason I say to just say no is because a lot of people are very uncomfortable saying nothing. But that is the answer. What you do not want to say is anything about how fast you are going. Don't say, well, I think I was only going. Don't say, I was going this much, or I was only going this many over the limit. No, don't say anything like that. Those are admissions of guilt. Those lead to tickets very quickly. You know how fast you're going? Nope. You know how fast I clocked you at? Nope. There you go. So there is your answer, AGK. JB, thank you for the donation. We've got Sixth Floor Madness, who says, gerontophilia, attraction to old people. Nursing homes are a swinger party for you. You're the walker smasher, granny panty invader, cucker of the reaper, get gum jobs galore or let Parkinson's do the work, and get a hella amazing hand job. Okay. That is horrifying. Thank you. Thank you for that. Blue Crimson 217 says, howdy, Grifter. Here's a chunk of my Corona pity bucks to get you another bottle of that Gretzky whiskey. Oh, the Gretzky whiskey? I guess. Oh, I do have a gift to share. Salty Jester says, you shadow banned rackets had to get here via Twitter. YouTube had no notification. No, that's the unfortunate function of doing the short videos during the day is that they eat up the notifications. You only get a limited amount of notifications. And if I could just choose one notification, it would be the live stream. And I would not give people notifications for anything else, personally. I don't think I can do that. Although I'm looking into if it's possible. And I'll be asking about it the next time I talk to YouTube. Because I think that's a feature that should exist. I think they really need to have some different features for live streams to help segregate them from other content. All right. James Karg says, Democrats sounding like Liberty Prime gone very genocidal. Quote, embrace democracy or you will be eradicated. And after watching Hamilton in the last third of the play, our politics have literally always been fighting like this, huh? Just why? Why us? Because it's too important. There's too much power. All of that power, no term limits, means incumbents, and incumbents get benefits forever. It's too much power. So it's too important. So people fight dramatically. Idea Machine. Says, this is all an elaborate meta grift for more super chats, and it's working. Oh, good. Yes. I will have my money stolen every night. Creeper Weirdo says, for Christmas, I got Berserk Deluxe and TMNT Volume 1, Yakuza Like a Dragon, and 2 Ray Harryhausen Blu-rays. You get any good Christmas stuff? No. Yeah. I don't know. I got to spend time with my kids. Other than that, we don't do a lot of, like, Lady Rackets and I don't do much for gifts with each other. We bought each other the Princess Bride board game to play together. But, I mean, there's, other than that, no, we don't really do a lot of gifts for us. Mithrin Emra says, but what if we ask you to chase as many rabbits down holes as possible? If we ask you to meander before getting to a topic with the imp of perversity, then make you get to the topic quickly. Inquiring minds, Nikki. Well, that's up for you to try. Okay. Let's see. That's where we are for super chats. I think we're ready to move on. Oh, one last thing. I did get a gift in the mail today. Here it is. This is 1792 full proof bourbon. This is I can't find this around me. It may be a couple hours away, but it's not anywhere near my town. This was the winner. This was the winner of the whiskey of the year last year. It is 62.5% alcohol. And I might have to try some tonight. But that is from my man Ryan. He says, try not to boomer this one, Nick. Merry Christmas. He was around for the destruction of the boss hog. So that is the reference there. And Ryan, I appreciate it. Thank you so much for sending this. And I'm going to savor some of it in just a minute. Mesha Kahari Russ says, lol, this is karma for missing the RGB joke last night. Just kidding. That really sucks. That happened to you, sir. I hope you're able to get it resolved. I'm pretty confident I will. Like I said, my bank is very good with addressing fraud, and I get very good service from them. So, actually, the entire trick of my bank tomorrow will be convincing them to not shut down my credit card. or my debit card, because my card wasn't compromised. Like, they didn't get the access to my card and go to Twitch. They were able to use my card because it was linked to Twitch. So they'll be able to, they should be able to reverse all that. But the trick is they're going to be like, oh, there's fraud. We got to cancel your card. And I'm going to be like, no, stop. The card is fine. That'll be the trick. Did I used to be a banker? Yes. Literally, yes, I did. Anonymity T2. No, there's not enough information on Twitch for them to compromise the card. My bank is not Wells Fargo. I worked for them. I would never bank with them again. They're horrifying. That's got some fire to it. Oh, the smell on this is not as prominent as I thought. I thought this would be very acrid smelling. Justin Tristano. Nope. The 2-factor did not hit my phone. They just got in. Somehow. Whoa! That is beautiful. That is fire and tingle all through the mouth. And it just lights up. And it hangs out there. Oh, that's good. Okay. I know exactly why that won. It's remarkably smooth when you swallow it. That's what she said. But no, it's a lot of activity in the mouth. That's good. Literally everyone. No, there will be no movie tonight because we'll be playing Ranger Spencer on Skyrim. But movie tomorrow. I still have full access to my Twitch account, and I've redone the security, changed all the passwords and everything. So there will be Twitch tonight. Just with a little bit of sadness to it. Okay. Woo! Robert Levito says, hey, Nick, how's the TV? It's fantastic. Lady Rackets and I watched an episode of Punisher on it right before this stream, and I am thoroughly enjoying it. Bad Vibe says, Nick, why should I give you money if you're just going to get it taken from you? Jeez, send your kids to school, and all you do is eat the books. Andrew War Snowboard says, your bank is good at addressing fraud, eh? Think we could get them to elect Trump? They would probably actually like him and support him. So they stopped the count in Georgia? Come on now. They did not. They did not. Oh my, of course they stopped the count. We'll wake up and the Republicans will be 4 points behind. Random 11, I don't have a SIM card. Dun dun dun. Anyway. All right. Let's go. Let's do this. Here we are. So here is the main document we'll be reading tonight. It is 24 pages. It is a memorandum of law in support of motion to dismiss. This is because Joshua Moon has filed a motion to dismiss this lawsuit. And this is the memorandum of law that supports it. Go figure. But there are some other filings that are in there, and I wanted to take a peek at them to illustrate just how far out of her league, Melinda Scott is when she is talking to an actual practicing attorney, especially one who practices in federal court. So, here we go. We're going to, not this one. This is Joshua Moon's opposition to motion filed at docket number 43. Okay, this is a sort of a throwaway document. It's only a couple pages, but it's important because I want to illustrate that Melinda has no idea what she's doing. Now, she will call this making fun of her for being a pro se plaintiff. It's not making fun of her. It's letting her know why lawyers and courts and literally everyone suggest people not try to do anything beyond very basic small claims litigation at the pro se level. Hire an attorney. If you can't hire an attorney, it's most likely that the claim is not going to work out for you anyway. So, oh, real quick, let me address this since people might have missed it. Some people are asking if Josh is coming on, or if I can get Josh on. I stated before, and I'll state it again. I'm not going to have Josh on during the pendency of this suit to talk about this suit. I don't want anything Josh says on this show to compromise in any way his actual legal case. I think that would be a bad thing. If he said something and it was able to be taken out of context or misconstrued by the crazy lady and used against him, that would be terrible. So I will invite him on immediately when this is resolved. And on the advice of his attorney, he can decide whether or not it is safe to come on at that point. If he wants to come on and talk about literally anything else, I always love talking to Janny Jersh. But for now, in regards to this suit, he will not be on. Okay? All right. Now comes Joshua Moon and opposes the plaintiff's motion to quash and dismiss defendant's request to vacate previous orders and for the issuance of a protective order / other relief, which is filed at docket number 43. In opposition, defendant Moon states as follows. Now, this is important because what happened was they filed a motion to dismiss and a motion to quash, and then, no, wait. Sorry. They filed a motion to vacate the prior order, the default judgment, basically. And rather than Melinda engaging in proper motion practice and filing an opposition to the motion, which is what she's supposed to do, she instead filed a motion. She filed a separate standalone motion to quash and dismiss the motion, which you wouldn't file a motion to dismiss a motion. That's not what would happen there. You would oppose a motion and request it to be denied. That's how motions work. Motions are either granted or denied. Typically, an action is dismissed, not a motion. But out of an abundance of caution, they have filed this supplemental document to address her standalone motion. So now they are opposing the motion. But here we go. The plaintiff has a curious habit of filing cross motions rather than simple oppositions to motions. Undersigned counsel originally understood the plaintiff's cross motions to be miscaptioned oppositions to defense motions and simply filed a reply brief. However, it now appears that the plaintiff intends for her cross motion to stand on their own rather than for them to serve as simple opposition briefs. Ms. Scott has filed at least one reply in support of her cross motions, which would otherwise constitute an unauthorized rebuttal. See docket number 44, addressing both the merits of setting aside default and the merits of a purported motion to strike. Defendant Moon moved for an extension of time to respond to the plaintiff's motion, filed at docket number 43. Because the court has not yet ruled on that motion and because undersigned counsel does not wish to violate the timelines imposed by Local Rule 11C1, Defendant Moon feels obligated to respond to the plaintiff's motion. So, you have to respond in time for the motion. This is also the problem with pro se plaintiffs, is they can just file bullshit and you have to respond to it at some point. Like, you have to deal with what they file because it's the rules. Even though they're drooling or foaming at the mouth while filing, you have to you have to go ahead and respond. All right. Plaintiff cites no authority for the proposition that a court can dismiss or quash a defense motion, and the defense is aware of no such authority. The plaintiff has not filed an opposition to the defense motion filed at docket number 35 and has not requested that the court deny any defense motion. Instead, plaintiff only requests this court grant plaintiff her 14th Amendment right to equal access to the courts, among other relief. Defendant Moon respectfully submits that the constitutional protections of the 14th Amendment apply to Ms. Scott by their own force, and that this court has neither the power to grant those rights nor the power to abrogate them. To the extent that Ms. Scott may have intended to file her motion filed at docket number 43 to serve as an opposition to the defense motion filed at docket number 35, Defendant Moon rests on his earlier filing and respectfully submits that Ms. Scott's latest filings only underscore the importance of ensuring this case is adjudicated in an orderly and expeditious manner, despite the plaintiff's proclivity for motions practice. So, some subtle jabs at Melinda's overuse of motions here, because motions that have to be responded to cost defendants money. And if she's engaging in frivolous motion practice, that needs to be taken care of as soon as possible. There was one other thing that I wanted to deal with, and I don't have it pulled up. Give me just a moment. Okay. Sorry, I thought it was in one of the ones that I had pulled up. I know people get annoyed when I have to go searching for a document. There's one mildly making fun of her request to have access to the, this one. This is that's the opposition to the second. Here we go. Here we go. Let's take a peek over at this one. You can see Josh's attorney getting increasingly annoyed with Melinda. All right, so this is Defendant Joshua Moon's response to the motion filed at docket 39. Docket 39 is, come on now. I'll just read you what it is real quick. It is, that's the pro se motion for extension of time to serve summons on Jane Doe and John Doe's 1 through 3. Okay? And we're going to get to the John Doe's 1 through 3 in just a minute, because they actually factor a lot into the memorandum of law. But now comes Joshua Moon and opposes the plaintiff's motion for an extension to file time to serve summons. Defendant Moon incorporates by reference the arguments set forth in number 35, as those arguments relate to the rapidly escalating cost of this litigation, which costs the plaintiff appear to disregard because she's filing in forma pauperis, which means that the court, not her, are paying for all of this motion practice. Normally, someone would have to pay a filing fee for every single motion, and all of these motions would cost Melinda Scott hundreds of dollars. But you're welcome. You, the taxpayers, are paying for Melinda Scott to be an idiot. You're paying for it. So, defendant respectfully submits that permitting the plaintiff to continue to actively litigate against one defendant while other parties remain unserved would only further escalate the cost of this litigation and make a trial on the merits or even a damages hearing in the current posture of default inefficient or impossible to conduct. Defendant Moon incorporates by reference the jurisdictional venue and forum nonconvenience argument set forth in his motion to dismiss, to the extent that this court lacks jurisdiction or elects not to exercise its jurisdiction on various prudential grounds, permitting the plaintiff to serve additional defendants would be futile. Defendant Moon further incorporates by reference his arguments relating to the plaintiff's failure to state a claim. To the extent that the plaintiff wishes to extend the deadline to serve a fatally deficient complaint, her request is futile. So, big slapdowns going on there. back to, this is the, motion to compel documents, blah, blah, blah. We don't really need to deal with this. There's one, and I thought it was in one of those, but there's one where he makes fun of the fact that Melinda is filing public case records. It might actually be in this memorandum. We're going to have to take a look at that in just a minute. So here we go. This is the memorandum of law in support of a motion to dismiss. So if you don't know what's going on, Melinda Scott has filed a frivolous lawsuit. There's no doubt about it. There's no sugarcoating it. Melinda, if you need to sue me for saying that, you can catch fire or whatever in Minecraft peacefully. But this is a frivolous lawsuit, and she filed it against the social services, Wise County Social Services. She filed it against Joshua Moon, and there is no merit to this case. There never was merit to this case. It's been dismissed against all the government parties. The only reason this lawsuit is going on is because she misrepresented her ability to serve Joshua Moon process. So she told the court that she had properly served Joshua Moon and that now he was in default. As he never received notice of any of this, including his supposed service, he was not able to respond, and the court ruled that there was a default judgment against him. As soon as he found out there was a default judgment against him, he pursued getting a lawyer, contacting and hiring a lawyer, and then filing this response. This is only there because probably the judge missed something when looking at this these filings. And probably because his eyes glaze over every time the same judge sees Melinda Scott's name. So, in the process of this, though, now Josh has retained a lawyer, and they are moving to vacate the default judgment. So get rid of it. A default judgment means you lose. And if they actually enter an award in judgment, you owe it like a regular judgment. But if you have a good excuse for why you defaulted, like I wasn't properly served, the court is obligated to vacate the default judgment and allow you to continue, which would mean that Melinda would have to properly serve Josh, or the court can just resolve it. And in this case, it looks like they want the court to just go ahead and resolve the case rather than have her try again. Okay? So they're trying to vacate the default judgment and then have the case dismissed, and then they will probably be pushing for some sort of sanction, like having her labeled a vexatious litigant, because she is a vexatious litigant whose sole purpose is to run up fees on defendants and waste court resources. So there we go. Bad Vibe says, thank God we have a lawyer who knows how to grift the humor and newsworthiness of a case we are paying for. Yes, you guys are paying for this. This is a federal case, and informa pauperis funds come from federal tax dollars. All right. Mr. Moon, an American who presently resides in the European Union, became aware of this case in the entry of default found at docket number 20 when he received entry of default by mail from the clerk's office. Undersigned counsel filed 2 simultaneous motions on December 7th, a mere 20 days after default was entered, and within days of undersigned counsel being retained. The first filing by Mr. Moon was a motion to set aside default, erroneously captioned as a motion to set aside default judgment. The second filing was a motion to dismiss. Now, the reason it's a default and not a default judgment is because they never actually had the default judgment hearing to get the judgment amount. So it's technically just a default, not a default judgment yet. Although the court doesn't care that it was captioned the wrong way. They know what's going on. All right. Because one of the factors this court must evaluate in ruling upon a Federal Rule of Civil Procedure 55C, motion to set aside default, is whether the party seeking to set aside default has a meritorious defense. Undersigned counsel felt it appropriate to file the 2 motions simultaneously to demonstrate the merits of Mr. Moon's defense for purposes of evaluating both motions. However, the plaintiff's briefing since December 7th has frequently commingled arguments that relate to the motion to set aside default, the motion to dismiss, and various of the plaintiff's own motions. Because Local Civil Rule 11C1 prohibits undersigned counsel from filing surreply or surrebuttal briefs without leave of the court, This brief will address only the merits of the motion to dismiss filed at docket number 26. If the court believes that further briefing on the other issues raised by the plaintiff relating to set-aside default would be beneficial, Mr. Moon would be happy to supplement his earlier briefs and address extraneous arguments which have been raised by the plaintiff in the interim. In the absence of leave of the court to address other issues, however, undersigned counsel confines this response to the merits of the motion to dismiss. This is an interesting strategic decision because what they could have done is they could have addressed a bunch of stuff in the motion, made it, bulked it out a little bit more. It's a lean 24 pages. But they could have bulked it out with a bunch of arguments to address these other things and confuse the case as much as Melinda has been trying to confuse herself. They could do that. But rather, what they're doing is they're indicating to the court that, one, this lady doesn't know what she's doing. Two, that not knowing what she's doing is costing the court resources and costing the client resources. And three, this thing needs to be resolved and resolved efficiently. And the judge probably doesn't need any extra help doing it. But if the judge wants any briefing, just let them know and they'll be happy to do it for them. They're letting the judge know, they're signaling to the judge, we understand your pain. We understand your pain, judge. Because the judge and the clerks have to read this too. We know that you're dealing with a lunatic. And because you're dealing with a lunatic, we want to go ahead and help you out here. Just get rid of this. Just get rid of it. Dismiss the case. Vacate the default. Get it out. If you need any more support, we'll give it to you. But we're not going to waste your time with extra documents. We love you, Judge. We love you. And under those robes, we would snuggle you. That's what they're saying. Okay. Standard of review. The pleading requirements for surviving a Rule 12b6 motion are well established. A complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face, in the sense that the complaint's factual allegations allow, quote, the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. This court, however, need not accept as true allegations that are merely conclusory, unwarranted deductions of fact or unreasonable inferences. So here's the arguments. So that's the rule. This is IRAC, IRAC, not IRAQ. IRAC legal writing. This is the way you write a legal document. It's intro, rule, argument, conclusion. In the intro, you talk about what you're going to talk about. In rule, you state the rule. It's usually a pretty brief section. They've stated the rules. Then in your argument section, you address the argument by applying the facts of the current case to the rules that you talked about. And then in the conclusion section, you tell the judge what you just told them. It's very basic high school writing adapted to the legal style. Tell them what you're going to say what you're saying, and then tell them what you just said. That's what it is. Pretty simple. Argument. As set forth in Mr. Moon's initial motion and its accompanying memorandum, this case should be dismissed with prejudice on any or all of several grounds set forth in Federal Rule of Civil Procedure 12. Alternatively, it should also be dismissed based on doctrines of forum nonconveniens, which means that the forum itself is not convenient to the defendant or the plaintiff, based on arguments made in the plaintiff's own response to the motion to dismiss and highlighted in the defense motion at docket number 45. It additionally appears that the claims Ms. Scott attempts to bring against Mr. Moon are barred by the doctrines of res judicata, claim preclusion, and or collateral estoppel. And on the last live stream, we actually discussed those concepts. The idea that these claims have already been addressed. Collateral estoppel is that this issue itself has already been addressed, even if they were by different claims. And res judicata is sort of the civil version of double jeopardy. Already litigated, already adjudicated. Guys, and if you're surprised that Democrats are going to end up winning Georgia, I don't know what to tell you. I don't know what to tell you. But that's what's likely going to happen. Because of course it will. Why wouldn't it? If it didn't, that would just be 2019 or whatever. All right. Process was facially defective in this matter. The plaintiff repeatedly conflates the issues of whether service of process was proper in this matter with the issue of whether process in this matter was proper. However, the two issues are distinct and are addressed by separate subsections of Federal Rule of Civil Procedure 12. The Fourth Circuit has also recognized the distinction and recently upheld a dismissal on process grounds, even in a case where service was not in dispute. Mid-South Carbon Corp versus Tri-Camp Capital. Rule 12b-4 provides that insufficient process is a defense that may be presented by a motion. Dismissal is the appropriate remedy when a summons is facially defective. Okay, so this is their service of process. That's the actual act of giving a lawsuit or a paper in a lawsuit to the other party. That is serving upon them process, okay? And then there is the process itself. You serve the process onto someone. Insufficient service of process means there was a procedural defect in how the process was delivered or not delivered to the other party. Insufficient process means that there is some defect on the paperwork itself, which is not service of the process. Again, that's a procedural defect on the process of giving the process. But the process is a noun. It is a thing. It is a stack of papers that you must serve on someone. And if those papers are defective, that is separate from the issue of the delivery of said papers. Okay? Melinda Scott doesn't understand this because she's not a lawyer. I know Melinda Scott thinks she's smarter than a lawyer, but she isn't. She's not learned on this subject. She is not trained on this subject. In fact, most fresh out of law school lawyers aren't either. But that's a different topic. Rule 12b-4 provides that insufficient process is a defense that may be presented by motion. Dismissal is the appropriate remedy when the summons is facially defective, as it was in this case. The summons is part of the process, summons and complaint. So it's quoting this Ayers versus Jacobs Crumplar case. A summons which is not signed and sealed by the clerk of the court does not confer personal jurisdiction over the defendant. It doesn't matter if you did the process of giving the summons to the defendant correctly if the summons itself is defective. That's what the argument is here. As the Ayers court held, a deficient or defective summons also presents jurisdictional problems. The validity of a court order depends on the court having jurisdiction over the subject matter and the parties. Without personal jurisdiction, the court is powerless to proceed to an adjudication. The summons in this matter was and is facially defective. It does not contain the court's name, much less the court's seal. The only signature on the summons is handwritten, and the signature's surname is illegible. The stamp on the summons indicates it was received in Roanoke on August 18, 2020, but that stamp was affixed by the U.S. Marshal Service and also fails to contain the name of the court that issued it. Even leaving aside the issue of whether the summons was served properly, the summons was itself entirely insufficient in this matter. It could not have been used to alert the recipient to what court was hearing this matter and was incapable of bringing any recipient with this court's jurisdiction and within this court's jurisdictional ambit. So they're saying that, again, in this one, the process itself was defective, not the service, not the procedural aspect of it, but the actual documents. So now we have service of process was fatally defective. And if this sounds familiar, it's because we discussed this the other night, and this is going to mirror the statements I was making about the defective service. The plaintiff's arguments relating to the service of process are unavailing. To the extent that Ms. Scott attempts to set forth arguments relating to how one ought to serve Lolcows LLC, an entity she has sued in the past but elected not to sue in the instant matter, those arguments did not permit her to sue Joshua Moon, an individual, in the same matter that she would be permitted to serve an LLC. She cites no law in Florida or Virginia that permits her to serve an individual at a business address, especially when such individual is not present. And the relevant federal rules only permit service on an individual at a place of abode. To the extent that the plaintiff recapitulates previous arguments relating to service by mail, those arguments have already been addressed at docket number 30. Lastly, to the extent that the plaintiff attempts to allege that the unnamed employee of the Quick Pack and Ship, who allegedly received the summons, was somehow an employee or registered agent of Mr. Moon, such an assertion is entirely without evidence or even facial indicia of plausibility. So part of her argument was that this random employee at like a UPS store basically Was somehow the employee of Joshua Moon and his agent authorized to accept service of process on behalf of himself? It's not. That's not right. That is completely incorrect. Christopher Murto says at 1,000 likes, they will donate $100. Well, that's on the stream, guys. I mean, that's not up to me. But apparently, I'm supposed to grift likes to get them up to 1,000. Also, as is customary, if we get to 1,000 likes, I will do a shot of whiskey. And this is high-octane whiskey, so it should be delicious and fiery. All right. When attempting to sue an individual in a foreign country, strict compliance with the rules for service of process is even more important than it is in an ordinary case. When the local sheriff knocks on a door of a resident in his own community with a summons to answer a neighbor's charges, the recipient usually reacts. When the summons calls on him to answer charges half a world away in a court he has never heard of, the party served may be less likely to bestir himself, not recognizing that a failure to do so may have serious adverse consequences. The Seventh Circuit reversed a default judgment in a case brought against an American defendant who had moved to Canada. In that case, the Seventh Circuit was particularly concerned because, quote, the evidence does not show who the person, the process server, served was. It might have been the defendant, but it equally might have been a third unidentified resident of the apartment, a guest, or a passerby. Equally, in the present case, the proof of service filed at docket number 5 does not indicate who the deputy U.S. Marshal served. Since a service on an unnamed employee at a quick package ship for further delivery to another unnamed third party comports neither with the rules of procedure nor with basic principles of due process. So again, they're saying that the service was completely ineffective. And it was. There's no doubt about that at all. Nor do the cases Ms. Scott cites to allege that proof of service was proper to support her own arguments. The plaintiff liberally cites Wade versus Alamance County Department of Social Services. Wade, although unpublished, directly quotes Armco Inc. versus Penrod Stauffer Building Systems. Armco directly contradicts the plaintiff's preferred notion that defects in service do not invalidate such service. We talked about this the other day. She cited a case and said that it meant that you could serve someone. And we looked at the case, or that you could have a defective service and that it would allow you to still be effectively served. And we looked at the case and it didn't say that at all. In Armco, the Fourth Circuit reversed a default judgment against a corporate entity that was not properly served, even though the corporate entity in question had actual notice of the lawsuit holding. The defendant, of course, had notice that an action had been commenced by the filing of a complaint. When the process gives the defendant actual notice of the pendency of the action, the rules in general are entitled to a liberal construction. When there is actual notice, every technical violation of the rule or failure of strict compliance may not invalidate the service of process. And that's the line that she quoted. But the rules are there to be followed. She left this part of the quote out. Melinda, this is dishonest of you, and courts hate it when you do this. But the rules are there to be followed, and plain requirements for the means of effecting service of process may not be ignored. This is particularly so when the means employed engenders this kind of confusion, which the defendant's officers reasonably experienced here, leaving them without clear notice of the necessity to respond. Since there was no valid service of process, the district court was without jurisdiction of the defendant, and the default judgment was void. Armco is a binding precedent in this circuit, which indicates that the rules, although liberally construed, are there to be followed. Even assuming arguendo that defendant Moon had actual notice that a lawsuit was pending, such actual notice is insufficient in this case for the same reason it was insufficient in Armco. Indeed, even assuming that defendant Moon had actually received the summons in the matter, the actual notice that he would have received would not have provided him any information about what court this matter was pending in, and would not have facilitated any swifter response on his part than he eventually provided by retaining legal counsel and seeking to set aside default less than a month after it was entered. Even if she had given him the documents, or he had gotten them from some other place and knew about it, it wouldn't have been enough. That's what they're saying here. And of course it wouldn't. Service of process is this interesting place where you get to pretend to be an absolute idiot. You can read every document that's filed on Pacer. You can read all these documents. You can understand there's a lawsuit against you. You can understand exactly where it is. You can see all of that. But unless they give it to you, you have not been served. It's a basic rule. That's why the rules are there. Now, guys, I have poured this drink of whiskey for you to get to 1,000 likes. And so I'm hoping you'll oblige. But you know, it's sitting here. It's just taunting me. So hit that like button and jack it up to 1,000. Plaintiff provides no citizenship information regarding the Doe defendants. And this is something I didn't touch on in the last one because I wasn't even thinking about the Doe defendants. These are unnamed John and Jane Does in the complaint. And I wasn't even considering their impact on diversity jurisdiction, although this is a similar issue in Toddy Westbrook's case. Here we have these unnamed defendants, and the problem with an unnamed defendant is unless you allege where this defendant may live, then they may live in the same state as the plaintiff. And if that's the case, you don't have diversity jurisdiction. And if this is a diversity jurisdiction case, which this one is, then you can't bring it in federal court if you can't have diversity jurisdiction. Okay? So that's the problem here. The plaintiff has provided no information in her complaint which relates to the citizenship of the Doe defendants. Although the plaintiff may well have limited information about the Does, her failure to allege their citizenship eviscerates her ability to invoke this court's diversity jurisdiction. To the extent Ms. Scott alleged the identity and citizenship of the Does in her response to the motion to dismiss, she alleges that they may be citizens of Wise County. That's the same county as her. That's a terrible choice, Melinda. If they're citizens of the same county as you, you don't have diversity jurisdiction, you can't bring this in federal court. Defendant Moon is happy to take the plaintiff at her word that she is suing fellow residents of Wise County, but such a claim defeats her own allegation of diversity of citizenship. District courts sitting in diversity are suspicious of John Doe defendants out of unease over whether plaintiffs purposely named John Does to avoid naming known defendants who would stand to destroy diversity. Sound authority supports the general proposition that the John Doe practice is unwarranted in diversity cases. While the plaintiffs naming John Doe defendants does not destroy diversity jurisdiction automatically, the plaintiffs must at least show that the John Doe defendants are citizens of states other than the plaintiff's states of citizenship. It is the plaintiff's burden to establish the citizenship of various John Doe defendants. A claim that fails to provide the court with information sufficient to invoke diversity jurisdiction must be dismissed. Quote, the action is subject to dismissal unless the John Does are eliminated or their citizenship affirmatively alleged. So one of the things Melinda could do is drop the Does from the case. She does that. She still loses her jurisdiction, and we'll talk about that in just a minute. 1 like away. There it is. All right. Here we go. 1,000 likes has been attained, and now I will take a shot, or maybe more, I don't know, of this whiskey. I have got to learn to measure shots. Whoa! That is a real fiery shot. Or two. Whatever that was. I think that had to be a double. Woo! Woo! Okay. I'm sure I'm not going to regret that in a little bit. That is not a gulping whiskey, we'll say. Just by astute observation, that is not a gulping whiskey. All right, so let's talk about why those John Doe defendants being eliminated is a problem. That's coming up in just a second. If the plaintiff is correct that the Doe defendants are Wise County residents, then this court has no diversity jurisdiction. If the plaintiff is incorrect, it is still incumbent upon her to provide sufficient information. Hold on. To establish the existence of diversity jurisdiction, and her failure to adequately allege the citizenship of the Does is itself fatal to her claim. Oh my goodness. There we go. Whew. Aggregation of claims does not create diversity jurisdiction. So this is the other part. With diversity jurisdiction, you need complete diversity of citizenship between the plaintiffs and the defendants, which means no plaintiffs can live in the same state as any defendant at all. If one plaintiff is in the same state as one defendant, then you defeat diversity jurisdiction. The court can't hear it, okay? The other part that this person is trying to get around is the other part of diversity jurisdiction is your case or controversy has to be worth more than $75,000, or at least plausibly alleged to be more than $75,000. It may end up being less. It may end up being more than $75,000 at the ultimate award, but you at least must plausibly allege it. She's only alleged $50,000 in damages from Joshua Moon and has not alleged a joint liability to the other defendants, because that would be ridiculous in this case. She's saying that the Joshua Moon caused her damage, and she's saying that the other defendants caused her separate damage. So since she has not alleged joint liability, she cannot aggregate the claims together to create that $75,000 number. Okay? And this is the other problem. Even if the court were to accept that she could aggregate them together, if you remove the John Does, then you get below the $75,000 threshold very quickly, and this case must be dismissed. She has completely screwed the pooch here. And, well, you know, with white girls and dogs. So, aggregation of claims does not create diversity jurisdiction. Plaintiff baldly states, must be a wig, the aggregated claims requirements set by law have also been met, but the plaintiff seeks only $50,000 from defendant Moon. Ms. Scott is therefore not attempting to aggregate multiple claims against a single defendant, but rather to aggregate all her claims against all defendants, including the unidentified Does, in order to reach the amount in controversy threshold. All she had to do was just allege that Josh Moon cost her $75,000. That's all she had to do. Simple reading of the rules would have saved her here. No worries, Christopher Murto. I trust you and believe you. The Fourth Circuit permitted aggregation of multiple smaller claims against a single defendant in order to reach the amount in controversy threshold in Shanagan versus Cahill. Aggregation of claims is ordinarily permitted only against a single defendant. Although claims committed by conspirators or jointly liable parties can occasionally be aggregated, quote, where the liability alleged is separate rather than joint, aggregation is not permitted even if the claims arise out of the same transaction. The Fourth Circuit has further held that aggregation is keyed to the type of recovery, not the factual relatedness of the claims. And again, this is a failing of her filing pro se rather than having an attorney, which she cannot afford, and also wouldn't take her case because her case is crazy, because she's insane. In this case, plaintiff has made clear what relief she seeks, $50,000 from Mr. Moon and separate sums from various other defendants. She does not allege conspiracy or joint and several liability. Thus, aggregation of the plaintiff's claims against multiple defendants is impermissible, and the threshold of $75,000 in damages for diversity jurisdiction has not been met. And you can also see here, this is a good demonstration, of why default judgments are a problem in general. Had Josh Moon not fought back, this would be lodged as a judgment against him, even though it is facially defective, which means it is defective on its money shot. It is defective on its face. So the judge really should be just dismissing this case outright. But the way default judgment works is, well, they were served. They could have responded, even though it's illegal for the court to take this case because they didn't argue it. We're going to go ahead and take it and do it anyway. That's how the court deals with this. This court lacks personal jurisdiction over Mr. Moon. The plaintiff makes all manner of factual allegations in her response to the motion to dismiss, some of which are unsourced and most of which are unsupported by any corresponding allegation in the complaint. As an initial matter, quote, a plaintiff need only make a prima facie showing of personal jurisdiction to survive the jurisdictional challenge. However, the burden is on the plaintiff ultimately to prove the existence of a ground for jurisdiction by a preponderance of the evidence. A threshold prima facie finding that personal jurisdiction is proper does not finally settle the issue. The plaintiff must eventually prove the existence of personal jurisdiction by a preponderance of the evidence, either at trial or at a pretrial evidentiary hearing. As noted above, with respect to the discussion of inadequacies of service of process and process itself in this matter, defects in the summons and the service of that summons may also deprive this court of personal jurisdiction over Mr. Moon, even if such jurisdiction could otherwise exist if the summons was proper. Quote, a summons not issued and signed by the clerk with the seal of the court affixed thereto fails to confer personal jurisdiction over a defendant, even if properly served, citing Ayers again. The complaint in this matter is largely devoid of allegations relating to Mr. Moon, much less allegations that relate to this court's personal jurisdiction over him. Paragraph 46 of the complaint alleges that Mr. Moon sent an email to a social worker, but does not contain the identity of the social worker's location, or any other information. Paragraphs 66 and 76 allege that Mr. Moon maintains a website and posts information on that website. Such allegations and others which failed to allege Mr. Moon undertook any act in or plausibly targeted at the Western District of Virginia are insufficient to establish this court's personal jurisdiction over him. Plaintiff's response at docket number 47 contains numerous additional allegations, including that Mr. Moon is a registered Republican with a domicile in Florida. Mr. Moon lives at his mother's home in Florida. Mr. Moon has significant business presence in Florida. Let's start reading some footnotes here. Defendant Moon has requested that his motion to dismiss be construed as a motion for a more definite statement if the court is not inclined to dismiss outright at this juncture. 3. To the extent that the plaintiff now alleges Mr. Moon's mother's residence is also Mr. Moon's domicile and claims to have verified his voter registration in Florida, the plaintiff undercuts her own argument in favor of serving him via an electronic mailbox rather than at his place of abode. This is what I was going to say. Good job. Because voter registrations are tied to residential addresses, she also undercuts arguments about being unable to locate any physical address at which to serve Mr. Moon other than the quick package ship. Yeah, here's the crazy thing. If his address is actually the same as his mother's, you can serve his mom on his behalf, but only if he actually lives there. Nathan Kish, yes, Melinda Scott is the Mountain Jew. That is her. Number 4, that Mr. Moon targeted the social harm and social abuse alleged in the complaint toward the plaintiff in her neighborhood, local area, local county, and state of residence as well, Wise County, Virginia. This is a conclusory statement. She hasn't indicated how he targeted her area specifically. So, you know. Neither the allegations in the complaint nor the plaintiff's allegations in her response to the motion to dismiss are sufficient to establish a prima facie basis for this court to exercise personal jurisdiction over Mr. Moon. To the extent that Ms. Scott alleges that Mr. Moon generally maintains a website, she fails to allege that the website targets Virginia or to allege facts which would make such a claim of targeting plausible. To the extent that Ms. Scott alleges Mr. Moon emailed a social worker, plaintiff fails to allege the identity or location of the social worker, further fails to establish how such an incidental or ancillary contact with a social worker via email could lead to the existence of personal jurisdiction, even if true. To the extent that Ms. Scott argues Mr. Moon has ties to Florida, she undercuts her arguments for a court in Virginia to exercise jurisdiction over him. Right, because that was one of the weird parts of her argument. Well, he has all these ties to Florida. Then sue him in Florida. But she didn't do that. She didn't do that at all. She sued him in Virginia. Even if this court were to hold that Ms. Scott had made out a prima facie case for the existence of personal jurisdiction, it remains her burden to prove the existence of such jurisdiction by a preponderance of the evidence. Under the circumstances of this case, Defendant Moon respectfully submits that an evidentiary hearing on the issue of jurisdiction would be appropriate if the court is not yet prepared to rule. An evidentiary hearing would minimize the expenditure of resources of counsel and the court in this matter and prevent the possibility of entering a judgment that may ultimately be void. And then the footnote says a judgment is void ab initio if the court has that rendered it lack jurisdiction of the subject matter or of the parties, or if it acted in a manner inconsistent with due process of law. So they're saying, okay, look, court, they're giving the judge all kinds of outs here, and they're doing that to be polite. But what they're saying is, court, you don't have jurisdiction. But if you're not quite sure, we would be happy to have a hearing on the matter and let Miss Melinda show you why there's jurisdiction. Just a Dude says he'll donate $1,500 if we get the stream to 2,000 likes. That seems very unlikely as there are 1,100 likes so far. But if you guys get the stream to 2,000 likes, you can cost some poor schmuck on the internet $1,500. So if you want to see him suffer, go ahead and hit like. There you go. That's that. Just to let you know, Just a Dude, YouTube will only take that in $500 increments, so you'd have to do 3. Diamond Duck 98, I know there's only 1,500 viewers. It's not me. He said 2,000 likes. All right. So again, what they're saying here is, look, court, she has the burden to prove this. If you're not willing to rule that you don't have jurisdiction, let's have a hearing on it. Let's just have a hearing on it. There you go. If we have a hearing on it, then that will solve the problem. That will solve the problem. Okay. So, number F, this court lacks subject matter jurisdiction. Oh, we're getting up there in likes though. 1,262. 1,262 at 1,800 likes. That guy's going to start sweating like crazy. This court has 2 potential bases. So there's personal jurisdiction and then there's subject matter jurisdiction. Personal jurisdiction says the court has a right to hold judgment over Joshua Moon. Subject matter jurisdiction says the court has the right to hear this type of case, this type of claim. This court has 2 potential bases upon which to exercise subject matter jurisdiction. First, the court could exercise subject matter jurisdiction if there was complete diversity in citizenship and the plaintiff reasonably expected an award of over $75,000 from any defendant. Second, this court could exercise subject matter jurisdiction if the plaintiff presented a federal cause of action. Here, the plaintiff has not pleaded complete diversity or satisfied the amount in controversy threshold for the exercise of diversity jurisdiction as set forth above. Neither has the plaintiff established that she presents a federal cause of action against Mr. Moon. Although the plaintiff's response to the motion to dismiss extensively discusses constitutional violations she alleges she suffered at the hands of Mr. Moon and contains arguments relating to her belief that Mr. Moon is a state actor, the complaint does not appear to seek relief against Mr. Moon for ostensibly federal cause of action. And even if the complaint did seek such relief, this court would not have jurisdiction to grant it. So, what she would need to do is bring a federal 1983 claim against Mr. Moon for acting under color of law, which would be ridiculous, but that's what she would need to do. That's what she would need to do. The complaint begins with the heading, Cause of Action 1, Violations of Constitutional Rights by Defendant Wise County Department of Social Services. Thereafter, the plaintiff details various ways she feels her constitutional rights were violated by the Wise County Department of Social Services. All such claims were dismissed by this court at docket number 14. The plaintiff argues for the first time in her response to the motion to dismiss that 2 paragraphs in her complaint allege that Mr. Moon is responsible for the violations of her constitutional rights, despite the complaint's heading, which appears to indicate she only seeks to hold the Wise County Department of Social Services responsible for such violations. The 2 paragraphs of the complaint that Ms. Scott cites to support her belief that this court has federal question jurisdiction contain the same operative sentence relating to Mr. Moon. Quote, Defendant Joshua Moon, John Doe 1, and John Doe 2 gave a social worker alleged information about the plaintiff using the social worker's employee email address. Ms. Scott does not explain how contacting an unnamed social worker at an email address constitutes a federal cause of action in either her complaint or her response to the motion to dismiss. Undersigned counsel is aware of no case holding that providing information to a social worker without much more constitutes a federal cause of action. Because it doesn't. That's why. That's why he's not aware of it. It's not real. It doesn't exist, like everything. Okay. We're up to 1,320 likes, y'all. Very cool. Very cool. Quote, federal courts, unlike most state courts, are courts of limited jurisdiction created by Congress with specified jurisdictional requirements and limitations. Accordingly, a party seeking to adjudicate a matter in federal court must allege and, when challenged, must demonstrate the federal court's jurisdiction over the matter. Constitutional violations are ordinarily adjudicated in federal court under 42 U.S.C. 1983, which states that every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. Okay, 42 U.S.C. 1983 is the claim you bring against government officials who wrong you, like police brutality, for example, or improper, imprisonment or confinement. Stuff like that is brought under this claim, this 1983 claim. That's what this is. That's where you may have seen it before. Footnote 5 says, because the complaint is so barren of allegations relating to Mr. Moon's alleged status as a state actor and appears not to seek relief against him as a state actor under 42 U.S.C. 1983, this memorandum will not address at length any possible defenses Mr. Moon might have to a hypothetical complaint that did raise such claims. If the court wishes to consider the allegations raised in Ms. Scott's briefing related to the claims under 42 U.S.C. 1983 as a supposed state actor, Mr. Moon requests leave to supplement his brief and reiterates that the lack of clarity in the complaint is among the reasons he moved in the alternative for a more definite statement of Ms. Scott's allegations against him. And again, this is giving the judge all of the free reign in the world. Judge, we're going to suggest that you dismiss this if you don't want to. We love all the leeway. We love you, Judge. You do whatever you want. You're the best judge. Man, I remember this judge. He's good. He was waving his dick around with Kavanaugh at a party. Those guys are great. A couple of wiener wavers. That's what they're saying in this, right? Like, they are fully on board. Judge, you have every out you could possibly want. Every out you could possibly want in this. But make the right decision. All right. In this case, Ms. Scott has not alleged that Joshua Moon acted under color of any statute, much less identified the statute at issue. As such, she has entirely failed to meet her obligation to demonstrate the federal court's jurisdiction over the matter. The plaintiff separately claims that the intentional infliction of emotional distress is a federal cause of action. It's not. However, although substantive claims for IIED under Virginia law need not be pled in federal court with the degree of specificity required by Virginia courts, the procedural differences between pleading a Virginia claim in federal court and pleading a Virginia claim in federal... Oh, there's a typo here. He means pleading a Virginia claim in Virginia court and pleading a Virginia claim in federal court do not transform the plaintiff's cause of action into a federal claim. It's a minor typo. It really doesn't matter. I just happened to notice it. Nor does the plaintiff cite to any federal statute which she believes gives this court jurisdiction to hear a claim for IIED. Real quick, intentional infliction of emotional distress is a cause of action in which the actions of a party, a defendant, are so egregious and shock the conscience so much and lead to actual damage to a defendant. That damage tends to need to be supported by some sort of documented medical issue, like therapy, for example. So you need some sort of sensory deprivation therapy because the person was screaming at you for 48 straight hours. I don't know, something ridiculous. And so you have a documented ailment that is traceable to the defendant, and you start documenting, and this is the important part of an IIED claim. You have to have real damage. You have to prove that you were damaged, and the way you do that typically is by documenting treatment. But a good example of what intentional infliction of emotional distress looks like is harming someone's loved one in front of them, making them watch, right? That gets a little bit extreme because there's criminal acts there. Let's say you pick up someone's therapy bunny, okay? You're like, "This your therapy bunny?" And they're like, "Yes." And they're crying or whatever. And you're like, "Here's your therapy bunny. Where's he now?" And you put a 45 up to the therapy bunny's head and you pull the trigger and you blow the therapy bunny onto the wall, right? Like some sort of nouveau art splatter work. And you're like, "There's your therapy right there on the wall. Eat it, lick it," whatever it is. That is intentional infliction of emotional distress. You're doing an action that is shocking to the conscience of a reasonable person, that you intentionally are causing severe emotional distress to the point where the person would need treatment for it. Okay? If you know that they have a rabbit, but they don't care about it because it's got a bunch of hypodermic needles with AIDS in the rabbit, like a pin cushion, a little mobile hopping pin cushion or something, and you're like, you kill their rabbit, and they're like, "I don't care." You knew they wouldn't care. That can't be IIED, even if that would normally shock the conscience. Like you smash that rabbit with a sledgehammer or something, that would shock the conscience of a normal person. But you can't possibly intend to inflict emotional distress when you know that person doesn't care about the rabbit. There has to be some sort of intent to convey that awful negative emotion to the other person. I don't own any rabbits. I like rabbits. I think they're cute. Ace Brain 2003 says, "Is it wise for a lawyer to choose to be a pro se litigant, or is it safer for them to hire a lawyer?" They should hire a lawyer most times. Witch Stitch Witch says, "What? My bun? Why?" No, not yours. Someone else's. It was an example. Save the rabbits. Okay. Let's read footnote 6 here. Ms. Scott also asserts that her claim for IIED is not time-barred. However, plaintiff fails to identify the date on which her cause of action allegedly accrued in 2018. And the assertion that any cause of action accrued in 2018 is inconsistent with allegations elsewhere in her various filings that the course of conduct she alleges Mr. Moon engaged in began in 2017. And I believe IIED's statute of limitation is 2 years. Therefore, it would be time-barred here. Alternatively, even if jurisdiction did lie for Ms. Scott's claim, this court is not the most convenient forum. So this is a far argument in the alternative that they're just making out of an abundance of caution, but it's not really necessary. There's no way this court should have jurisdiction over Josh Moon. But they're saying even if this court somehow does, it shouldn't be brought here. It should be brought probably in Florida is what I'm guessing. Ms. Scott appears to not to have addressed defendant Moon's forum nonconvenience arguments. Ms. Scott's venue arguments appear to be based on unsupported and even facially implausible allegations that Mr. Moon's website targets Virginia. Defendant Moon respectfully submits that the plaintiff's allegations and arguments relating to venue in the Western District of Virginia are almost indistinguishable from her arguments that this court has personal jurisdiction over Mr. Moon. If the court declines to dismiss the case outright or on the ground of forum nonconvenience, this court could address the question of whether to transfer this case to another U.S. District Court, allowing an evidentiary hearing on the question of jurisdiction. And that would be Florida. Florida would be the most reasonable thing because she has alleged over and over that Josh Moon has all kinds of ties in Florida. In fact, I think she alleged that he literally lives in Florida and is just lying about living in the EU. Something that other Kiwis have alleged as well. What are you hiding, Mr. Moon? Are you a night owl because of Twitch thoughts? Did you hack my Twitch account, you motherfucker? I bet it was. I bet it was Josh Moon who hacked my account. A forum nonconvenience dismissal must be based on the finding that when weighed against plaintiff's choice of forum, the relevant public and private interests strongly favor a specific, adequate, and available alternative forum. The moving party bears the burden of showing that an adequate alternative forum exists. In this case, even assuming arguendo that this court has the ability to exercise personal jurisdiction over defendant Moon or subject matter jurisdiction over this case, there's no reason to believe that this court is the best forum for adjudicating the plaintiff's claims. To the contrary, this court is convenient only for the plaintiff, who is elected to bring numerous claims in the courts of Southwest Virginia against Mr. Moon and others. Aside from conclusory allegations that Mr. Moon owns a website and emailed a social worker, Ms. Scott has failed to establish why Wise County is the best forum for this action to be tried. The courts of the European Union, where defendant Moon actually resides, and Florida, where plaintiff asserts he resides, are both adequate fora. Oh! I thought it would be forums. Fora is the plural of forum? To adjudicate any claims Ms. Scott wishes to bring forward. Because Ms. Scott has repeatedly attempted to use Florida Quick Pack and Ship as her jurisdictional hook for a targeted and years-long litigation campaign in state and federal courts against an individual who has never lived in Virginia or conducted business in the Commonwealth, public policy may also favor a resolution in Florida. In the Sunshine State, an individual who files a suit against another person or entity without merit, and primarily because such person or entity has exercised the constitutional right of free speech, is subject to sanctions under state law, Florida Statute 768.295, Subdivision 3, Florida's anti-slap statute, which would be very bad for Melinda, even though she can't pay, so it wouldn't really matter. What's up, Versi? How you doing? Thus, a dismissal of this matter on forum nonconvenience grounds would not only facilitate a more convenient resolution of this case for Mr. Moon, but would force the plaintiff to reevaluate the claims which she has admittedly filed in this and various other Virginia courts in order to chill speech on a website that she dislikes. Damn. All right. Plaintiff has not made out a claim for IIED. So now we're going to get into the merits of this claim. Jimmy the Hand says forums equals more than one meeting. Fora equal more than one meeting place. You learn something on the internet every day. Every day. That's amazing. Fantastic. As this court recently held in Leitner versus Liberty University. Hey, Liberty U. Claims of intentional infliction of emotional distress carry a disfavored status under Virginia law. To state a claim for IIED, the plaintiff must plead the following. The defendant's conduct was intentional or reckless. Conduct was outrageous or intolerable. There was a causal connection between the defendant's conduct and the plaintiff's emotional distress. And 4, the resulting emotional distress was severe. It is not enough for conduct to be insensitive and demeaning to satisfy the second element of an IIED claim. Yeah, you can't just, be mad because someone walked around and called you an F slur or some other gamer word. That's not IIED. Even if you are a fragile SJW and your entire world was shattered because of some person saying a word on the internet, that's not actually enough. It must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Here, the plaintiff's assertions, even if accepted as true, create no plausible claim for IIED against Mr. Moon or anyone else. Plaintiff cites paragraphs 66 to 80 of her complaint as grounds for a belief that Mr. Moon is liable for her emotional distress. Defendant Moon will address each paragraph in turn below. Paragraph 66 claims that Mr. Moon owns a website. Defendant Moon's ownership of a website is insufficient as a matter of law to give rise to any liability for Ms. Scott's emotional distress. Paragraph 67 alleges that a website Mr. Moon owns contains information about the plaintiff and court documents she has filed. Such an allegation is also legally insufficient to give rise to a claim for emotional distress. Paragraph 68 is a sentence that fails to identify any specific actor who undertook any specific action. Paragraph 69, 70, 71, 74, and 75 do not allege action on the part of Mr. Moon. Paragraph 72 mentions Mr. Moon's name, but fails to allege any action on his part and contains only conclusory allegations that the various individuals had a plan to engage in unspecified conduct. Paragraph 73 indicates that Mr. Moon is responsible for contributing to a phone call, but does not indicate how he allegedly contributed to the phone call in question. I honestly don't know how you contribute to a phone call. Do you guys know how? Like, is it you give them 3 digits of the phone number? Is that how you contribute to a phone call? So yeah, the Georgia counting stopped at 97% reporting. You gotta love it, right? Of all the things Georgia had to do, they had one job. It was count the damn ballots tonight. That's all they had to do. One fucking job. Just count the ballots. Paragraph 76. I'm trying to keep my cool, y'all. You put whiskey in me after someone stole a bunch of my money, and now you're pulling bullshit in Georgia. We're all supposed to just gobbledy that government penis. That's what we're supposed to do. Azurian, that's no surprise. It's okay, guys. They'll sue about it in Georgia, in Georgia state and federal courts, and they'll be told that it's too late to sue, even though they tried to sue beforehand. That's what's going to happen. Welcome to it. I'm going to make 100 videos on it. I can't pour another until that gentleman donates me $100. You owe me $100. I'm joking. I'm joking. All right, back to this. I have to be calm. We're calmly reading this and analyzing it coolly from a legal standpoint only. Paragraph 76 alleges that Defendant Moon owns a website and contains conclusory and legally incorrect allegations relating to immunity under Section 230 of the Communications Decency Act. That same paragraph alleges that Defendant Moon has twice posted Miss Scott's address on a website. And to be clear, I honestly don't care. You don't have to give me $100. I'm just kidding. Please. Like, I don't. You don't owe me anything. I just did it for the whiskey, in all honesty. Like, I'm the Grift King, but that's pretty fucking petty. No worries. No worries. In fact, it would be funnier if you promised me $100 and didn't pay me. So don't do it. All right. Here we go. The same paragraph alleges that Defendant Moon has twice posted Miss Scott's address on a website and that he has participated by posting comments and information about the plaintiff. Such allegations that Mr. Moon has posted comments on a website likely fail to constitute any tortious conduct on his part at all, but especially fail to rise to the level of demonstrating Mr. Moon went beyond insensitivity to disregard the mores of a civilized society. Paragraph 77 is a legal conclusion that the plaintiff suffered severe emotional distress, but also indicates that she was filled with anger and rage rather than despondency or humiliation. Whoops! That's not emotional distress. That's being pissed. Paragraph 78 is a legal conclusion about the alleged common interest various defendants have in causing the distress mentioned in paragraph 77. Paragraph 79 alleges that the plaintiff is not responsible for the actions of other parties. Paragraph 80 alleges that Joshua Moon can identify individuals who are being sued as does. Simply put, none of the allegations in paragraph 66 to 80 of the plaintiff's complaint show that Ms. Scott was a victim of intentional infliction of emotional distress inflicted by anyone at all. Now, counterpoint, minor counterpoint. The minor counterpoint of that is Just because the individual paragraphs don't lead to the cause of action doesn't mean that the total wouldn't. In this case, they don't. In this case, the combined paragraphs of 66 through 80 don't lead to liability in any way. But even if they did, you could probably go through and pick out the individual paragraphs and say, well, this doesn't lead to liability. Well, this doesn't lead to liability. But combining multiple ones, you may get there. In this case, it doesn't. But I just want to point out that that is not always a good argument. Not always a good argument. Whoa, Dogsplain with $100 through Streamlabs says, because some people like to welch, enjoy, but I ain't doing 1,500. Thank you, Dogsplain. You didn't have to do that. Why did you do that? I appreciate it, though. Instead, plaintiff's own complaint. Oh, wait. Yeah. None of them shows she was a victim of intentional infliction of emotional distress inflicted by anyone at all. Instead, the plaintiff's own complaint contains only allegations that she is filled with anger and rage. Even assuming arguendo that Ms. Scott could demonstrate intentional infliction of emotional distress by some set of individuals, however, she has failed entirely to allege what actions Mr. Moon took to cause her distress. Those few actions that Ms. Scott allegations Mr. Moon undertook, alleges. Another typo. Guys, everybody makes typos in court documents. Everybody does. Undertook are benign, time-barred, legally insufficient to give rise to liability, or some combination of the foregoing. The only way to avoid typos in your court documents is to hire a drunk lawyer to read them online. That's it. That's all you can do. That's the only way I know of that you get around typos in court documents. Allegations of true threats and cyberbullying are absent from the complaint and insufficient as a matter of law. Pages 13 to 14 of the document filed at docket 47 contain a section that alleges that plaintiff is a victim of cyberbullying and that such cyberbullying is a true threat. Such allegations do not appear in the complaint, and the plaintiff has not cited to any paragraphs in the complaint to support her allegations of cyberbullying. Look, Melinda, you gotta amend your complaint. That's what you would have to do here. I mean, it's too late, and your complaint is completely terrible, and you are terrible for bringing it, but you'd have to amend your complaint to add a cause of action to it, and cyberbullying is a separate cause of action. The crux of the plaintiff's cyberbullying allegations appears to be that she believes documents posted on Oh, this is it. Listen to this. Let's start this over. The crux of the plaintiff's cyberbullying allegations appears to be that she believes documents posted on Pacer should not be released to the public on various websites. Plaintiff appears not to understand that Pacer is an acronym that denotes a system that allows for public access to court electronic records. Melinda, the P is for public. The P stands for public, not for pool, right? Trouble with a capital T, which rhymes with P, which stands for pool. Stands for pool. No, public access. Nor does the plaintiff reconcile her belief that documents posted on Pacer cannot be copied or posted any elsewhere within the Supreme Court's holding in Nixon versus Warner Communications. That, quote, courts of this country recognize a general right to inspect and copy public records and documents, including judicial records and documents. Of course, it's public, Melinda! Ms. Scott may not have yet been declared a vexatious litigant. But she is nevertheless a particularly persistent litigant in this court and others in Southwest Virginia. She is elected to sue numerous defendants on multiple occasions and has now sued Mr. Moon no less than 5 times in 3 courts in recent years. This court has previously recognized in Scott versus Carlson, Scott versus Wise County Housing Authority, that the plaintiff is in the habit of filing information publicly, which she either should not publicly file under the rules of court or later wishes to seal. Although it is understandable that, by the way, Melinda, you ask for permission to file confidentially first, not after you file it publicly, you dummy. Feel like Mark Levin. Well, listener, you gotta file for confidentiality first. You can't come into court asking for confidentiality after you made it public. You dummy. You can't do it. Although it is understandable that Ms. Scott now feels embarrassment at the information she has filed with the court in an attempt to seek six-figure judgments to which she is not legally entitled, republication of Ms. Scott's voluminous litigation history is constitutionally protected activity. The plaintiff's voluntary disclosure of information does not overcome the presumption of public access to judicial documents, and, quote, private interests in certain personal information are not protected once that information becomes relevant in a lawsuit. You brought it, Melinda. Nobody told you to do it. Nobody told you to do this. You did it. You're an idiot. That's why I'm able to broadcast this to the world. Your dumbness can be seen by everybody because you did it. Section 230 immunity applies. And even if you didn't, like, this is Josh Moon's issues too. He didn't ask for this. He didn't ask for some crazy batshit insane woman to file a bunch of lawsuits against him. That's not what he wants. He wants to run his weird little website. That's all. That's what Josh wants to do. Leave him alone. Leave him alone. You crazy lady. Section 230 immunity applies. Ms. Scott asserts at docket number 47, page 14, and docket number 47-1, page 8 and 9, Mr. Moon is not immune from liability under Section 230 of the CDA. Her arguments run headlong not only into her own allegations in the complaint, but also the case law she herself cites and the universal holdings of other courts that have interpreted Section 230. So, go figure. Her arguments are just simply incorrect. Oh! The Democrats have taken the lead. I thought they stopped counting. What are you guys talking about? A huge swing in favor of the Democrats. Amazing. Purdue just lost like 5,000 votes just out of nowhere. RKO. Out of nowhere. Purdue. They started again? Well, I mean, of course they did, right? Because you're going to stop the count. Well, you're going to start it again once people, like, kind of leave. Guys, you have to smile and laugh along. You have to do it. We're at 1,428 likes, y'all. The plaintiff chiefly cites Nemeth Chevrolet Limited versus ConsumerAffairs.com and Zarin versus America Online for the proposition that plaintiff Scott adequately alleged in the complaint in this case that defendant Moon permitted illegal defamation on his website from other users. Plaintiff Scott further argues that defendant Moon does not qualify for immunity because he interacts on threads, develops content, distributes information, has the ability to re-edit content on threads. Leaving aside the issue of whether Mr. Moon has permitted illegal defamation on his website from other users, citing footnote number 9, plaintiff has not adequately alleged defamation by any individual or set forth the basis for a defamation claim in this matter. Such material is exactly what Section 230 protects him from being held liable for. In Nemeth, the plaintiff sued for comments posted online that it alleged were false and harmful to its reputation. The Nemeth plaintiff even argued that certain online postings were fabricated out of whole cloth by the defendant. The Fourth Circuit rejected Nemeth's claim on the basis that state law plaintiffs may hold liable the person who creates or develops unlawful content, but not the interactive computer service provider who merely enables that content to be posted online. and that Nemet's well-pled allegations allow us to infer no more than the mere possibility that the defendant was responsible for the creation or development of the alleged defamatory content at issue. In Zarin, the plaintiff's suit related to allegedly defamatory statements posted on an online bulletin board. The Fourth Circuit rejected Zarin's claims that the bulletin board's owner was liable for defamatory content under multiple theories of liability, all of which were preempted and barred by Section 230. The plaintiff further attempts to impose liability on Mr. Moon because he allegedly has the ability to edit content on KiwiFarms.net. The plaintiff further alleges that Mr. Moon occasionally posts content himself on KiwiFarms.net. Even if the plaintiff's allegation that Mr. Moon posts on the site personally are true, plaintiff has not identified what allegedly defamatory material Mr. Moon posted himself, and her claim in this matter is not a defamation claim. All right. Such an argument is unavailing. Both Nemet and Zarin speak to Section 230's legislative intent to encourage ISPs to edit and filter content. Yeah, that's the whole point of 230. They want them to censor things, and they want to shield them from liability as a result of censoring things. That's something that people don't really understand about 230, I don't think. But it is permission to censor without worrying about the consequences of censorship. That's why the broad authority under 230 is the problem. Okay. Such an argument is unavailing. Both Nemet and Zarin speak to Section 230's legislative intent to encourage ISPs to edit and filter content. Quote, another important purpose of 230 was to encourage service providers to self-regulate the dissemination of offensive material over their services. And quote, 230 forbids the imposition of publisher liability on a service provider for the exercise of its editorial and self-regulatory functions. Now, I will offer a mild criticism of this document here. It doesn't talk about why Josh as an individual qualifies for 230. Now, the reason it doesn't is because it shouldn't have to anyway. It's based entirely on Melinda's argument that Josh is responsible for something someone else posted on his website as the owner. But I don't think, I mean, part of the argument is that he is not lolcowfarms.llc or kiwifarms.net, that he is not those things, and that he's an individual. Therefore, personally, I would have just rounded out that, you know, why he is the owner and content provider in this case. And I would have used Melinda's arguments to do so. I would have said, as the defendant has stated, Mr. Moon is the purveyor of the website, the owner of the website, and therefore those Section 230 immunities extend to him personally rather than just as an internet content provider, as a business. We usually don't think of a person as an ISP or an internet content provider. So I think they could have fleshed that out. It's not really necessary. It's a very minor criticism and probably irrelevant, but just in my current state and reading the document, that's a place that if you were saying, look, this could be a little bit more fleshed out, that's where. Everything else in this document has been phenomenal, so I'm not criticizing it in any way. Captain Sharky says, you may grift our money, but you'll never grift our freedom. Did you guys see Kamala Harris? Kamala Harris allegedly just stealing, plagiarizing a Martin Luther King story to apply it to her own childhood. By the way, every one of those, my 4-year-old came up to me and read to me the theory of relativity. And I asked how they learned it, and they said, because Trump is a bigot. Like, every one of those stories pisses me off. No, they didn't. No, they didn't. You know how I know? My kids are smarter than those kids. And my kids don't do stuff like that. I'm like, hey, what are you up to? And they're like, oh, I'm coding a new map in Minecraft with scripts. I'm like, you're 7. What's wrong with you? Go outside. Like, it's cold, though. Good point. Like, this is nonsense. And the classroom was Anne Frank. Oh my God. All right. We're almost done here. Res judicata, collateral estoppel, and or claim preclusion bar Miss Scott's claims. Miss Scott's own filings demonstrate that res judicata, collateral estoppel, or claim preclusion bars her claims in this matter. The plaintiff begins her own preferred history of her various claims against Mr. Moon by detailing her initial suit in the Wise County General District Court in May 2017. Following a discussion of her eventual appeal to the Wise County Circuit Court and decision to transfer her claims to this court, she alleges that this court had already found Mr. Moon qualifies for immunity under 47 U.S.C. 230. She further states that this is an IED case, not appropriation, defamation, or other torts. Plaintiff Scott has not previously filed an IIED case against defendant Moon. Footnote. Plaintiff also argues that the case is not prohibited by the doctrine of collateral estoppel because this is the first IIED claim the plaintiff has ever brought against Joshua Moon. Here's a hint. If they've got a footnote and they're leading in with their opponent's argument, they're about to destroy their opponent. Unfortunately, however, the plaintiff's own filings also demonstrate that she is suing Mr. Moon for one continuous course of conduct. She alleges at docket number 47, page 8, that she is suing Mr. Moon for a course of conduct that she alleges started in 2017 and has continued to the present time. Virginia law, however, squarely prohibits Ms. Scott from continuing to litigate the same course of alleged conduct over different legal theories or successive causes of action. Ooh, sorry. Uh-oh. Oh, no. Originally a creature of the common law, Virginia has now codified the doctrine of res judicata claim preclusion. Virginia Supreme Court Rule 16A states that, quote, a party whose claim for relief arising from identified conduct, a transaction, or an occurrence is decided on the merits by a final judgment shall be forever barred from prosecuting any second or subsequent civil action against the same opposing party or parties on any claim or cause of action that arises from the same conduct, transaction, or occurrence, whether or not the legal theory or rights asserted in the second or subsequent action were raised in the prior lawsuit, and regardless of the legal elements or the evidence upon which any claims in the prior proceeding depended or the particular remedies sought. And this is not unique to Virginia. This is a common thing because look, if you're going to sue someone over a particular event, you sue them for everything you've got. And if you lose and you come up with something later, sorry, you should have come up with it earlier. That's it. That's it. Hence, whether Ms. Scott prefers to style her claims as claims for appropriation, bogus, as claims for defamation, bogus, or as claims for IIED, the dispositive issue is not what cause of action she alleges. Instead, the dispositive issue is whether her claim for relief arises from the same identified conduct. It is indisputable on the face of Ms. Scott's own filings that her claim for relief in this case arises from the same conduct that she alleges Mr. Moon began in 2017, which conduct has been litigated now in 5 lawsuits spanning 3 courts. Conclusion: this court should dismiss Ms. Scott's claims against Mr. Moon with prejudice. Alternatively, this court should dismiss the claims under the doctrine of forum nonconveniens or construe the motion to dismiss as motion for a more definite statement pursuant to Federal Rule Civil Procedure 12E. And we've got 2 footnotes. First one says, undersigned counsel has begun but not yet completed the process of drafting an appropriate request for Ms. Scott to withdraw certain filings, which request will comply with the notice and safe harbor requirements of Federal Rule of Civil Procedure 11C2. Mr. Moon intends at the appropriate juncture to file a motion for sanctions against Ms. Scott. Defendant Moon respectfully submits that a dismissal will not deprive this court of the authority to impose such sanctions. See Cooter and Gell versus Hartmax Corp. And then footnote number 13. Undersigned counsel has attempted to address all issues raised in Ms. Scott's complaint and in her response to the motion to dismiss, with the exception set forth in FN1 Supra. Footnote 1 Supra. So footnote 1 above. Because the complaint and subsequent plaintiff's filings appear to take a scattershot approach to pleading requirements, Defendant Moon respectfully requests leave of the court for supplemental briefing on any issue that the court feels Mr. Moon may not have addressed. See generally Heather M. versus Berryhill, holding that a scattershot approach to briefing destroys the clarity of a party's position. So, very simple. Joshua Moon is asking for sanctions. One of those sanctions will be naming this insane woman a vexatious litigant and stopping her at the onset from filing further actions against him. A vexatious litigant would have to go before the court and get permission to file a lawsuit against someone by making their prima facie showing ahead of time. That should happen for Melinda Scott. She should also be put in some sort of home for people addicted to lawsuits or addicted to losing lawsuits, one of those two. Either one would be sufficient. She needs to be removed from decent society. She is a liability to herself and a detriment to others. The reality of this is, this is probably costing Josh thousands of dollars. Thousands of dollars. And that's just not fair to him. There's nothing he can do about this. There's nothing he can do to prevent this crazy lady from suing him. She's crazy. Crazy people do crazy things. You can't take a rational action to stop them. So, that's the problem that she's got, or that he's got, is that she is costing him thousands of dollars. That's why he needs to name her a vexatious litigant. As funny as it is for us to have to read Melinda Scott's inane and insane ramblings, in the long run, she is damaging and dangerous to people around her. Economically dangerous. She's probably not physically dangerous because she has children hanging from her nipples, like swinging around as she runs after you like some sort of crazy baboon. Like that's not intimidating or terrifying in any sort of way. Her entire danger comes from the fact that she has no cost of entry because she is so poor and useless that she gets the state to pay for her ridiculous actions. And until that stops, she won't stop. I guess that is kind of terrifying. You're right. That is a little bit of frightening. I guess I would be horrified by that as well. Like her weaving Hebrew magics at you, like drawing stars of David in the air or whatever, and firing Kabbalah spells at you to put various Jewish hexes on you. I don't know what she does. She's a weirdo. She's a weirdo. And she needs to be stopped. That's what needs to happen. Well, Google has called the election for Raphael Warnock over Kelly Loeffler. But they have not called John Ossoff versus David Perdue yet. So, that's how that goes. Just so you know. Woo! Oh my goodness. Oh my. Google, by the way, they get their information from Associated Press. So I guess AP has called the election. But yeah, where do you guys think the blame lies? I think it's Mitch McConnell. By the way, have you checked out my video, Everybody Hates Mitch? Everybody should hate Mitch McConnell. That guy's a piece of shit. But Mitch McConnell is a big reason the Republicans lost Georgia. Big reason. Look, I am not a fan of government stimulus. I'm generally not. But I will say that when the government locks down and shuts down businesses and employment for 8 months, they have to do something. They have to do something. Not everybody generates income from YouTube or whatever. Some people need to work like a real job. And if you can't work your real job, then what are you supposed to do? Like I know a ton of people whose jobs have been severely impacted. Friends of mine are, they do in-home sales, for example. They're an insurance person or a real estate agent. They do in-home sales. Well, real estate agents are a little different because the real estate market's doing pretty well. But in-home sales, insurance, you can't sit down in someone's living room. They don't want you there. Severely impacting that type of business. So once you start doing that, you shut down retail operations, you shut down restaurants. Waitresses, bartenders have been absolutely fisted by these government decisions. Barbers, massage therapists, chiropractors. You shut them down, what are they going to do? Like, they still have bills to pay. 600 wasn't enough. It wasn't enough. Trump said so. A bunch of economists said so. Democrats said so, which gives it less credibility. But that's the reality we're at. 600 wasn't enough. And the writing was on the wall that 600 wasn't enough. They needed to go higher. And the bullshit about fiscal responsibility, that rings hollow when you're giving hundreds of millions of dollars to Israel and like Qatar and fucking Pakistan. Like, okay, wait a minute. You're not willing to increase the outlay to U.S. citizens by a couple $100 billion, but you're willing to give hundreds of billions of dollars away to other countries? It just doesn't ring true. Oh, we're fiscally responsible, but you're racking up debt over here. That doesn't jive with what you're saying. Anyway, there are very few, like the Georgia runoff, the blame for the Georgia runoff lies squarely at the feet of a few people. I don't think they've even had to cheat to get Loeffler to lose. Purdue might be a different story, but he's behind right now. It was rigged, you fool. Was it, though? I don't think they needed to rig the Georgia election. I really don't. I'm not putting it past them, but I don't think they needed to. No signature verification equals rigged election. We're not even at that stage yet. They don't even... I shouldn't be arguing. Doesn't matter. Witch Stitch Witch says, Kentucky is in the top 10 highest percentage of poverty in reported states and territories and are his constituents. Willful, malicious neglect of your own people should be a crime and tried. Yes, a rigged election matters conceptually, but I really don't think they needed to for this election to go to the Democrats, for the Georgia election. You guys can disagree. That's okay. I'm not saying they didn't rig it. I'm saying they didn't need to for the Georgia Senate runoffs. Look, just to do 5,000 votes lost with the flip of the switch. That just happens. What are you talking about? Anyway, we'll see how it goes. Hopefully there will be some lawsuits over it. We can cover it. We can cover the court saying that the lawsuits are coming too late to change the election. It'll be great. It'll be great. Sir Keckington, again, I'm not saying they didn't cheat. I'm saying they didn't need to. I'm saying they didn't need to. A re-vote is a different animal than the original vote. You have to motivate people to do it. Look, if they so thoroughly cheated in the 2020 presidential election that they demotivated people to not vote in this one, they wouldn't need to cheat. I think they did. Whether or not they cheated is irrelevant. I mean, it's relevant, but I don't think it's relevant to the outcome, is what I'm saying. So, we'll watch what happens over the next couple days. I mean, I'll be covering it, absolutely. So, this will be fun. This will be a great idea. I wonder who boycotted the election in Georgia, the Republicans that boycotted it. That'll be interesting. I wonder if they'll regret boycotting it or not. I don't know if they do. We'll see. We'll see. Like I said, I'll be covering it. I'm sure there's going to be all sorts of allegations, hopefully some lawsuits, some interesting stuff. Did you guys see that they're moving to disbar Lynn Wood and Sidney Powell in Detroit? I'm going to have a video on that coming out tomorrow. They're attacking lawyers in Arizona. I'll probably have a video on that one coming out tomorrow. Lawyers that are not Lynn Wood and Sidney Powell down in Arizona. That's the next phase, if you don't know this. I don't know if you guys are aware, but here's the new thing for lawyers. You represented the wrong people. Now we want your license. You represented the wrong people. You did your job, but we don't like who you did your job for. Now we want your license to practice law. That's coming. That's coming. It's already happening in Arizona. It was just announced today that it's happening in Detroit. And the only reason I didn't have a video today is because it came out at like 7 p.m. So we'll be watching those. Again, if you're interested, check out if you like political and legal, like short legal stuff, I put that out all day, 3 to 5 videos a day. If you want immediate access to those videos, because sometimes they sit and wait for various things on the back end of YouTube, or they're waiting for a thumbnail or whatever. If you want immediate access to those, you can join the channel. Join the channel at the $2 membership level. That's all it takes. At the $2 membership level, you get immediate release of any videos that I put out. So there you go. And you get a bunch of fucking notification spam. You're welcome. You're welcome. Anyway, that's for you, those of you who are not currently members. All right, let's do super chats, and we might wrap this show up a little bit earlier. I don't know if we actually will. There's quite a few super chats to get through. But we've got Phil Vanderzee says, we need to talk about some good news. Hey, Rackets, what do you think about what's happening in Michigan with regards to the recent Michigan Supreme Court ruling on the government keeping 100% of proceeds of tax foreclosure auctions? I have no idea about that. John Moriarty. To get Discord access, you join Patreon or Subscribestar at the $5 plus level. Or you join YouTube at the $10 plus level. I know it's inconsistent, but that's how it is. And then if you join YouTube at the $10 plus level, send me a message somewhere showing me that. Showing me that $10 plus level subscription. I will get you access to the Discord. DM me on Twitter. Send me an email. Whatever it is. We'll get it to happen. There's technically a post somewhere in the community tab, but it's probably hard to find now. Let's do some other good news real quick. Did you guys see what happened in Pennsylvania today? In Pennsylvania, there's a dispute over one of the state Senate seats. It was decided by like 24 votes or something crazy. And the Republicans in the state Senate said, no, we're not swearing this asshole in. He can sit over there in the corner. We'll swear everybody else in. But there's an existing legal challenge to that vote. And so the Republicans in Pennsylvania, the Pennsylvania Senate anyway, actually stood up and had a spine for a second and said, no, we don't like this. And then when the president of the Senate, or whatever, I don't know if that's the right title, the chairperson, refused to like do what they asked, they voted him out. No, the lieutenant governor. They're like, nope, get your ass out. Get out. We're going to put our own lieutenant governor in for today. He's going to preside over this ruling. And you're going to sit there like a bitch in the corner. And they actually did it. It was amazing. So, good job, Republican senators in Pennsylvania. All right, let's do these chats. And we'll go over to Twitch so that someone can hack me. Crusader Saracen says they probably cloned your phone number to get past two-factor authentication. Any chance of getting that situation with Twitch resolved? I don't know how they would clone my phone number. My phone number is not public. And the two-factor authentication goes through a third-party app. So I don't know that having my phone number specifically would do it for them. I don't know how they did it. Like, I really don't. But I guess that's possible. But my phone number isn't really public. Like, that's relatively private. But yes, there is plenty of chance to get it resolved both through Twitch and through my bank. So that's what I'll be working on tomorrow. Vegito says PAD certified. I don't think so. Turbo Garbage says only just caught up on the Twitch shenanigans. Same happened to me, but they bought hundreds of channel subs to Russian streamer with 2 followers. Twitch was very slow and shit helping, but my bank was a lot quicker, better. Oh yeah. So the way banks handle this, or at least my bank handles these sorts of things, is I call my bank and I say, these are fraudulent purchases. I didn't make them. My bank provides me a provisional credit. So here we go. We're going to give you all the money back that you lost, and then we're going to investigate it as best we can. And you work on your end to get it refunded by the source. And if the source refunds it, as that happens, we'll remove the provisional credit. So tomorrow, I'm going to call my bank. I've already sent my banker a message, but call my bank and I'll say, hey, here's, you saw what happened. I sent you the message. Now I need that provisional credit, and they'll give me my $10,000. And then what they'll do is, as Twitch refunds my money, they'll reduce the provisional credit amount, and they'll keep whatever difference Twitch doesn't want to give me. Although Twitch should give me all of it because it's completely aberrant behavior in regards to my account. I don't do that. I don't give anybody bits on Twitch. It's just not a platform I actually like attend and watch other things. So I do super chats on YouTube to creators that I like. I don't tend to watch Twitch streams. Not my preferred entertainment. Bad Vibe says, Insanity is doing the same thing and expecting different results. Literally Scott's actions. Yes, Melinda Scott is an insane person. Okay, so here we go. Mario Carter 13 says, $40,000 taxes, plus $40,000 kitchen, plus $40,000 worth of Warhammer. It's not 40 grand worth of Warhammer, plus $5,000 TV, plus 10K Twitch thottery equals one very happy H&R Block employee. My kitchen is paid for primarily by insurance. Thank you. Because that was a thing. And I did not spend $40,000 on Warhammer. I think last year it was about $2,500. But the 5K TV is right. And then now 10K of Twitch thottery. Yes. Yes. My subscriber count Says, Jesus, ever since Nick started putting out those short vids, I've been moving at Kenyan murder machine speeds. Yes. And again, I've seen some people who don't like the short videos and that it floods their notifications. Again, I want to be able to segregate live stream content from clickbaity, spammy content. I would love to. I want that. YouTube doesn't give me the ability to do that. So if people are mad at it, I understand. I'm sorry. I wish it wasn't that way. I wish I could just do my live stream and have my channel grow. That would be wonderful. But YouTube is actively suppressing it, and what I was watching was the slow heat death of my channel starting. So I had to prevent that. But I also want to preserve the live stream for you guys, for me, because I enjoy them. I like doing this. It's my favorite part of this job. And it's something that I enjoy greatly. So I keep doing the live streams, and I want to keep doing them. If I could somehow get Twitch or YouTube to segregate them out, I would love to do that. All right. Crusader Saracen. You can't grift with 5-minute videos? Lord Shulk. Oh, man. I'm sorry to say it, buddy, but some of those 5-minute videos make more than any of these live streams. It's crazy. It's crazy. I had my I had one video go to 700,000 views. That video, and a good chunk of those views were demonetized before YouTube actually monetized it. And that video is one of my highest earning videos of all time. It's crazy. Crusader Saracen says, say, Nick, do you adhere to the Mike Pence rule of not being alone with another woman without your wife? If so, have you ever gotten weird looks or questions for it? Yes and no. I'm not strict about it, but I rarely find myself alone with another woman. I don't know why I would, but generally I do try to avoid it because I don't have any reason to be in a room with another woman alone. First of all, I don't respect them. Just kidding, ladies. Just kidding. But no, there's just no reason for it. Usually we can meet in public if we have to meet. And if we're not meeting in public, you know, we're meeting with me and Lady Rackets. That's just how it goes. Colonel J says, hey, Nick, when is your next e-girl stream? I really like that first one. Also, good show. At 20,000 Twitch followers, I have promised an e-girl yoga stream. Let's see. Knight of Hopex says Civil War. Polio64 says the blame lies with the GOP for abandoning low and working class white people to pander to minorities that don't care. Tear it down. Damn. Damn. Officially over. Ossoff won. Is that how it's going now? Republicans lose both seats. The Associated Press has not called it for Ossoff yet. I mean, it doesn't look promising, but all right, Tacoon513 says, hey, Nikki boy, stopping in to say hi. It's been a while since I've stopped to be on a stream. Hope all is well and Happy New Year to you, Beta. Tell Gundam I said hi. Will do. Thank you so much for stopping by. Tall Skinny Geek says, what's everybody drinking? Well, I've been drinking this full-proof 1792 whiskey, which is high octane, and I really like it. Andrew War Snowboard says, YNTF? Am I still in this state? I need to get to Texas pronto, or am I crazy? Dude, Texas is great. Chris French says, I wish I could drink with everyone, but I have to work. Damn. Literal Gamer says, hey, Nick, did you hear? Ohio just joined the Stand Your Ground Club. The governor just signed it into law. I did. That is great news for Ohio. Stand Your Ground should be the default law in every state. It's dumb that it's not. Mitchell Godsend says, remember the dude from last night asking about how hard it would be to get money back from Twitch? Think he might have had something to do with it? I don't. Oh, yeah. That guy? No, I don't think he had anything to do with it. But that is funny. Zero Absolute Zero says, New York Bill A416 allows forced detention of anyone the governor deems a threat to public health indefinitely. Well, what's freedom anyway? Who even cares? How dare you, bigot? Stabby McStabwood says, can I get a shout out for Mrs. Stabby? She's in labor at this very moment. Just waiting for the doc to show up. Get that baby out. Get it, doc. Hopefully you're out by now. It's 1:30. That was at 11:15, 2 hours ago. Good luck. Good luck. I don't know what stage of labor she was at, but it can go really fast. It can go really slow. Hopefully it's a fast, painless one. Get that baby out. Get that baby healthy. Ace of Spades says, hey, Nick, #1 grifter of 2019. Did you see your clip in It's a Gundam's newest video? You look so kawaii. Yes, I did. I did. It's about time that son of a bitch included me in a video. Goodness gracious. Super Black Cat 13 says, you take longer when someone tells you to go faster. No wonder you got 5 kids. Lady Rackets refuse to learn. You don't like being told what to do. Mad Clock says, can you give some insight on why you wouldn't bank with Wells Fargo? I've had them forever, but I'd like some insight from an anime lawyer. Look, it's just my personal experience with Wells Fargo. I don't like them. I don't like their philosophy of banking. I have had better customer service from other banks. My current bank right now is a much better bank than Wells Fargo for me. And I don't think that they have any interest in servicing existing customers. And it's not their fault. They have a lot of incentive to get new customers and new products. Not a lot of incentive to retain old customers in existing products and serve them well. So it's a bad business philosophy in my perspective when it comes to banking, but that's what they do. Death Trout says, by the way, when I was at Wells Fargo, the motto of Wells Fargo internally was called Go for Great, GR8. And that meant 8 products or services per customer. And the reason was because research showed that if you got 8 products or services per customer, that's like a checking account, a savings account, a debit card, a credit card, a personal line of credit, a home equity loan, we're at 6 now. Some other products, I don't even know, investment account, something else. If you could get 8 products, it became so difficult and frustrating for that person to transfer their services to another institution that they statistically wouldn't do it. Oh, like a mortgage would be another one, a car loan, renter's insurance, Wells Fargo did, an annuity, something like that. So that was their motto, was Go for Great. And the reasoning behind it was literally explained. Once we get them into 8 products, it is too frustrating and difficult for them to leave to another company, and they will stay with us out of convenience. Fuck that. Don't like it. Death Trout says, had someone steal $80 from my account through PayPal. Luckily, my aunt works for the bank I use and helped me get it resolved quickly. Perfect. Good job. Booty Appraiser says, hey, Nick, what made you decide that you wanted to be a lawyer? I lived in a small town. All of my skills were tailored to things that were not retail, and I hate retail work. And there was no employment other than retail work. So I said, I can be a lawyer anywhere I am. That's the end of it. Bad Vibe says, you don't need to make fun of anyone. You can, but your peanut gallery razzes everyone. Yes. Timothy Reaper says, if you start selling a suit and tie print on t-shirts, call it the Ricada lawsuit. I don't have kids, but I'm old enough to get away with dad jokes. Mario Carter 13 says, you oppose pro se, yet your wallet got goatsy. Demonic Loki says, have a shot on me. Cheers. Happy New Year. I don't know if I need another shot right now, but thank you. Broverly Bruh says, maybe it's because I'm drinking too, but you look like a brunette version of Remus Lupin. Expecto Patronum. Okay. Lonnie Holcomb says, smash the like button. It feeds the algorithm. It does. We're at 1,557 likes, guys. Fantastic. Bad Vibe says, I've been violated. Bad Vibe says, Nick prefers chilled whiskey, not speech. Look, only chill your whiskey if it's bad whiskey. Mario Carter 13 says, congrats to Senate Minority Leader Mitch McConnell. Ooh, vote him out. Get rid of him. Fighting Slug says, Doug T is up to 273,000 subscribers. You got to grift harder, Nikki. Look, I love me some Doug. Love Doug T and what he's doing, but he is able to state things in a way that I cannot state them. That's just how it goes. Like, I have some level of duty to say things that some people don't like. Like, I don't think this is going to work, for example. People don't like to hear that. They would much rather hear the rah-rah. I've been trying to avoid doom pilling entirely. There's some things where I'm like, like, I would love to report that Wisconsin actually flipped for Trump. Didn't do that. Nothing of the sort happened. I'd love to report that Georgia flipped for Trump, but it didn't happen. Now, what Doug is talking about typically is like a popular or a proverbial flip, not an actual electoral flip, but the fact that someone has done some research and found out that there was enough fraud that it should be flipped. Yeah, and power to him. I wish I could say that, but I can't. It's a little bit different for me. So, but that being said, I am perfectly happy with my growth and success over the past month. It's been phenomenal. Fighting Slug, yeah, he reported Arizona flipped as well. But again, if you go if you go watch his video, and I watched his Arizona video, it's up to like 2 million views, which is crazy. Go watch his Arizona video. He didn't say anything non-factual in that video at all. He talks about exactly the logic behind what he's saying. And he even says, I believe, that it's not a flip it's not a legal flip for Trump, but it's a flip on the public populist level. So, but yeah, I wish Doug all the success in the world. He's doing great. And I think he'll continue to do great in the future. He's a very smart, sharp guy. All right. Joseph Kerwin says, is the Mike Pence rule protective enough? Should one avoid being alone in a room with any less than 3 wives? Crusader Saracen says, say, Nick, in your opinion, should adultery be a capital offense or at least a punishable offense? No, I don't think so. Without considering how to enforce it or prove it, I'm leaning towards the idea that it should be punishable, but I want to hear your input. No, I don't think it should be a punishable offense in a criminal aspect. It is punishable civilly, and it should be. It should be punishable civilly, but it shouldn't be criminally punishable. I don't believe in the state getting involved in that sort of stuff. AGK says, disagreement is great, makes for more interesting discussion. Also, Mitch has his goiter of a neck, and his goiter of a neck need to be voted out. All right, guys. Thank you so much. That is the show for tonight. It's been a great show. I'm going to be over on Twitch in a little bit, lamenting the loss of a lot of money, but playing some Skyrim. Ranger Spencer has to clean Skyrim of non-Nordic races. And if you want to enjoy hanging out and doing that with me, please do. They're fun streams. Maybe I'll do diplomatic immunity today. Cosmic Corsair. Ranger Spencer is my parody of Richard Spencer for role-playing games. He is an ethno-nationalist Nord, and all he wants to do is peacefully relocate the non-Nord races out of Skyrim with a giant hammer. So if you guys want to come hang out and have fun laughing at that roleplay and enjoying that, especially his particular hatred of orcs, who he finds to be responsible for the majority of crime in Skyrim, you can come do that. So, all right, guys. Thanks a bunch. I'll see you over on Twitch in a little bit. Let's play that outro, shall we? All right. Drexel is coming out tomorrow. We'll probably be doing some chill streams, maybe even on the Ricada Media channel. If you want to hang out for a Drex stream, make sure and check the Ricada Media channel. We've got some video games to play and some less serious topics to discuss. So come over there, subscribe on Ricada Media. If we're not covering like serious topics, we'll probably be over there. Who knows what else will come up, but he'll be here tomorrow, Thursday, and Friday. As far as that goes, that's that. Also, all the short content is coming as well. All right, guys. Thanks for hanging out. We'll see you soon. Peace. Peace. Wait. There are 2 super chats. 1 super chat that I missed. Superstitious Oblivious B says, "Why you lying, Nick? I saw you in Pokemane's chat." Pokemane didn't get any simp bucks from my account, so that wasn't there. I only missed 1 super chat. I read the one about Mitch and his goiter. Don't even at me on this. Don't even at me on this. All right, catch you guys later. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour